there is retirement involved in a case, and that retirement needs to actually be divided. In other words, it's not just an agreement that each party keeps their own, right, and the retirement's not going to be touched. If it is going to be divided, it can only be divided through a qualified domestic relations order. If we're, dealing with like 401ks or 403bs or kind of those big like federal type plans. So that's just what we call a QDRO, and every retirement financial institution out there knows what they are. And most of them have a template that they can use to help get that qualified domestic relations order drafted. Sometimes in more complex cases, we need to bring in an actuary that can actually go into, the retirement accounts that we have on the table and figure out exactly what is community property that should be divided and what is separate property that should not be divided. So anything that obviously that people bring into the marriage with them on the retirement side is going to be their separate property. Anything they contribute after the date of separation is also separate property. And so then the job of the actuary is to find out kind of the in-between bit, right? The stuff that's actually community property because it was contributed during the marriage. And one of the trickier things is once the date of separation happens, right, whenever someone decides that the marriage is over and like file a petition or whatever they do to, advance that notion that they don't want to be married anymore, those contributions again become separate property, but the community property portion that exists on that day also continues to grow just because of the market forces that the retirement, hopefully makes it through. Lately, it's been a bit of a rocky road in the retirement world, but the job of the actuary is to evaluate what is the community property value plus the increase or decrease in value from date of separation, and also isolate the separate property value and, what is that worth and what needs to be subtracted from that property division. One of the most common questions I get about retirement overall is, well, we don't want to divide the retirement because, we don't want to have to pay the taxes on the, withdrawals. And as long as they're not liquidating anything in the retirement accounts, it is a tax-free transfer. So it's just divided, rolled from one account into another account. As long as the money doesn't come out of the plan, it is not a taxable event. So although I get that question a lot, again, it's important to understand that because that may change when we get to the place where we're talking about how to wheel and deal with retirement, which is really kind of the main focus, I think, of the questions today. You can use retirement to offset or add some sweetener or whatever to a particular proposal, even if that proposal is dealing with non-retirement assets. So say for instance you've got a home and the home has $500,000 in equity, and ordinarily what you would do if you're going to keep the home is you just pay the other side their half of that equity, $250,000. What they might propose is, hey, instead of me paying you that $250,000 in cash, why don't you take extra retirement money? And that could be fine depending on the parties and what their goals are. Or for instance, if the retirement is already at a payout status and the parties are kind of old enough to not have to worry about like the 10% penalty for early withdrawal, that may be okay, but you still have the issue of the tax question. Because if you want to use any of those funds that get transferred over from the retirement account, for instance, to buy a new house, because you just got bought out of the house that you were living in, right? So maybe you need some money for a down payment. If you just get $250,000 in retirement dollars, it's not worth the same as if you got a check for $250,000, right? Because that also tax-free transaction, anything that happens in a property division in a family law case is tax-free. There's no tax consequences to that, with that one exception for retirement. So if they've got a check for $250,000, this gets deposited and they can spend $250,000. If they're taking the money out of extra retirement that they got instead of cash, they're going to pay taxes on that retirement withdrawal, and sometimes they're going to have to pay a penalty too if it's an early withdrawal, if it's already not in pay status, which means $250,000 isn't worth $250,000. It's worth $250,000 minus 40%-ish of the tax and the penalty. So that makes that a kind of transaction unappealing. It doesn't mean that you can't do it, but typically what we're going to do is we're going to gross up the amount of retirement that is replacing the liquid cash payment. So we've got to make it worth $250,000, which means to get there, you've got to pay some amount north of $250,000. So if the person that's receiving the money, if they decided to withdraw it all, they have, at the end of the day, after taxes are paid, $250,000. So on the other side, on the retirement person side, where they're saying, I'll give you more retirement, that can make that situation unappealing, because maybe now all of their retirement is gone to pay for the house. So there are ways, to kind of work with a partial retirement payment, or if there's just a ton of retirement and not a huge amount of an equalizing payment that's got to be made to equalize the property division overall, it can still work, but it's an issue, and people struggle, and including attorneys, with how we gross up the amount of retirement. In one case, we had a couple that had a very, very expensive home. They wanted to, keep the home with mom for the sake of the kids. The kids were, I think, 12 and 13 at the time, and so they wanted to stay, home base for the children in that school district all the way up until they graduated from high school. So this was an interesting situation, because we also had quite a lot of retirement. It was going to be a big gross up, right? But the question in this case became, how do we bridge the gap between what we're doing with the house right now and then 4 or 5 years down the road when the house gets sold? Because that was the plan. Sell the house at the end of, once the kids are off to college. And then figure something out to split the equity at that point, right? And so that's another complication. Do you value the house at the time of the divorce, or do you value the house at the time that it's actually sold, 5 years after the divorce? And what does that mean for kind of balancing the equities in the property division, and how can we maybe use retirement to grease the skids a little bit for us? So what we decided to do in that case was just value the home as of the date of the sale. So there's going to be some presumed equity growth between, when the parties signed off on the agreement and when the property was going to be sold. And the party that was in the house, mom, would still have to make all the mortgage payments and have to pay for all the property taxes and all that. But we were expecting a good 6 to 8% growth in the bottom line. So in exchange for that agreement, for mom to cover all of the carrying costs and still let dad, enjoy all of the growth in the equity when the property was sold, we agreed in that case that we could use half of the equity payment in the form of retirement that was not grossed up. So that kind of helped out dad, because he wasn't losing, an extra $350,000 in his retirement. It helped mom, because her main concern wasn't so much liquid cash available. It was, what do I do at retirement, because I was the stay-at-home parent and I don't really have any retirement assets. So this gave her a good chunk of retirement. It gave her the security of being able to stay in the home, which was great. And the payoff to dad was that, even though he's not getting his half of the equity now, it's really an investment for him, because that property is going to be worth more in 5 years. And so it was just an ability to kind of balance all of their various interests, fears, and just handle it in a way that was going to have the least, tax impact that we could come up with. So that actually turned out to be a pretty good resolution. Then this scenario comes up, unfortunately, quite a lot when the only real asset in the case, well, there's two real assets, right? It's the house and it's retirement. And there really isn't anything else, right? And if in this party, this couple had the same goal as the prior couple, right? They wanted to keep the house for the sake of the kids. But there was a problem because there was no other asset that they could use to equalize the property division, because the house was really the only asset outside of the retirement. And so for mom, who wanted to keep the house, for her to pay out her share, or the other party's share of the equity from the home, she would have lost her entire retirement. It would have been all gone. And that is not something that she could contemplate. Again, these parties were a little bit younger, but they didn't have a huge upside on the retirement front. Again, these people were firmly middle class. They worked hard, but they weren't the Rockefellers by any stretch of the imagination, and hadn't really had an opportunity to accumulate a big community property estate. So the question then became, is there a way that we can, make dad happy with something less than half in the property division? And he had his own issues, right? Because he was, again, losing his home, and he had to find somewhere to go. And, rent has been ridiculous lately, often substantially more than a mortgage payment, even with rates the way that they are. He was going to be struggling with that. He needed cash. And the only way to get that cash was through, a check written from, his former spouse for his share of the equity, at least in part. She couldn't qualify for a refinance. The loan that they had could not be assumed, which means you get to keep the same rate. You still have to go through a qualification process for that, but a refinance could not happen. So the only way this could have been done is if dad was okay with just taking straight up the same amount of retirement instead of those real dollars, which means he would have had to have waited until he was retirement age to use any of them without getting penalized, and then he would have to pay taxes on them too. So it was not a situation. We worked and worked and worked to try to find something that we could do, some finagling that would be appealing to him. And it's nothing against him as a person. He just needed to make ends meet, and the only way to do that was, to get him some cash from the house. And so ultimately what had to be done is the house had to be sold. And that's, obviously the worst case scenario. And I had hoped that the retirement could be some kind of fulcrum point where we could, reach some sort of equilibrium. But the reality of their situation was that just was not going to be possible. So unfortunately, we couldn't work it. But we did talk about it quite a lot, and couple of hours on that issue in mediation to try and find a solution. Ultimately did not work. Mediation only gets you so far, right? There's nothing magical about it, although it can feel that way when all of a sudden a case that felt like it was never going to end suddenly resolves. That feels like magic. But mediation can only get you so far, and the real world and people's real situations are always going to come into play. And my focus is always going to be on planning for the future as opposed to hanging too much onto the past. There's nothing we can do about the issues that led us to this point, right? That's all part of the historical record, but we can plan for tomorrow. But there was no way that the planning for tomorrow could have involved anything other than the sale of the home, unfortunately. And that was true for both parties. Without dad really sacrificing his well-being. And look, he had those kids too. He was going to be spending equal time with those kids, and without a place to live for them, that's not good for the kids. Even though they had to move their school district, they moved some distance away, but it wasn't huge, so it didn't affect like their extracurricular activities or sports or anything like that. But they did get into a new school, and it was not the best resolution. But that's not, that's nobody's fault except the fates that said that this marriage was not going to work out. We did what we could and we tried, but we just couldn't use the retirement as a really meaningful device to get a better agreement on the table. the kind of weird case that can happen sometimes. And this comes up, and sometimes unbeknownst even to the parties, which is exactly what happened here. So we had, a couple that had a business together, and also had other jobs outside of the business. And in one of these jobs, the husband had a really interesting retirement plan that included several different optional plans that that he opted into when he took employment with this company. One of which was kind of like a motivation for him to stay with the company. It was like an incentive-based retirement. Whereas if he was still employed by the company at retirement age, and he was, I think, 38 when the case was finished, then he would have this pretty substantial amount either retired as retirement pay over time, or that could be paid out in a lump sum with some discount on there. It was like 650 grand or something that thing would have been worth. So, of course he said, sure, I'll opt in for that, no problem. He didn't have to pay for it. It was just kind of an incentive to stay employed at the company, and another benefit that would come to him if he worked there for another, 25 years. So that obviously is a very valuable asset, right? And so part of our agreement was that, he would be willing to give that in its entirety to the other party, assuming that he got it, right? And so then the question became, well, how do we really value that? Because today it's not worth anything, because he hasn't worked at the company for the next 25 years, and we won't even, if the company goes out of business, that's off the table. And if he decides to leave the company, that's off the table. So it's a very theoretical asset. And the conversations we had around that were interesting, because the greatest fear on the part of the other party, on the part of wife, was the retirement savings, because she had dedicated a lot of time to the business that they both owned, but that business didn't come along with any retirement benefits, right? So her retirement was essentially zero. And so part of what incentivized the property division in this case was granting to her the right of those funds as part of the overall retirement package for some other concessions that were made in consideration of how valuable that thing could be. And of course that comes with risk, and the risk is real. If the husband had left that post, then all of a sudden that thing becomes worthless, right? But from his perspective, he had no intention of leaving the company. Very big company, very good company to work for, and he had done very well with them. So it's not like he had an inkling that he was going to leave, but that requires an amount of trust in your now former spouse that can be insurmountable at times. And the issue, after the divorce had been finished, and after the marital settlement agreement and judgment paperwork had been filed with the court, we got a little bit of what we all call cold feet. And she reconsidered her agreement on that front and really wanted more real retirement that she could definitely count on. And so that led to some renegotiation, and that renegotiation is ongoing, and I don't know that it's ever going to result in any meaningful change to the judgment, which has been very stressful for both the parties. So the wisdom here is, think carefully before you sign the dotted line, right? Because this is now a judgment, and it's not easy to change a judgment. It's very easy just to change agreements during the course of a mediation before we get to the point where we are, signing off on the thing. But it is very difficult, if not impossible, to get the court to say, yeah, you're right, I'm just going to throw that judgment out. That is not what the court does. And so now we're kind of stuck with this agreement that she felt good about before, but does not feel good about now. And, part of the thing that I try and bring to every mediation is this sense that you can really salvage whatever can be salvaged out of this very important relationship in your lives. And it's important to me that people don't leave the process hating each other, right? I want them to have at least a civil relationship, because this is something that's always going to be with them, and it's formed part of who they are. as human beings, especially if you have children. That relationship is going to be going on and on and on forever. So that's really important. And unfortunately, I think in this particular case, it's really salted the earth with regard to how likely a collaborative, cooperative, somewhat civil relationship is going to be in the future. So that was really unfortunate. But it is what it is. Sometimes you roll the dice with these retirement questions, and when you've got kind of unusual aspects to a retirement plan, it really is important, I think, to get consulting counsel involved to kind of walk through the permutations of what might happen before you're making decisions about what to agree to and what to sign off on.